Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by Brenell. And Brenell, thanks so much for taking the time to speak with us. And perhaps maybe we can get started. You can tell us a little bit about yourself and your practice and what you're doing as a paralegal.
Absolutely. So basically, I became a paralegal 5 years ago now. I opened my practice, Dean's Paralegal Services, as a sole proprietor. And shortly after, within the first 2, 3 years, I became a partnership. I brought on paralegals initially. And over time, the demand grew, and now I'm Dean's Paralegal Services and Lawyers. So I've partnered with both lawyers and paralegals. It's been rapidly expanding.
Yeah, so maybe tell that. Let's start there because I think that's interesting that you have you have your practice there and you have paralegals and lawyers working with you, and kind of how did you get through in terms of that growth and making that decision? Okay, I want to work alongside lawyers because it's not, I mean, very it's pretty unique. I mean, it's not very often you see too many sort of multi-purpose firms with paralegals and lawyers kind of in partner type of roles. So what kind of gave you the motivation there to bring in, I mean, first of all, the paralegals? Maybe you can tell us a little bit about how you experienced that growth, and then the decision to bring in a couple lawyers and how everything kind of runs at your firm.
So during COVID, I got extremely busy for some reason. I know a lot of people slowed down and some people had the opposite effect. So I got just extremely busy. So I brought on paralegal partner to help with the workload. Over time, we had exceeded 1,000 active files at one time. So the demand was just rapid. We couldn't find enough licensees. And that basically opened the door for us to think about lawyers. Clients were starting to ask for appeals and things outside of scope. With COVID, the demand for legal services grew. And we thought, well, I guess this is the time. So it basically forced our hand to consider lawyers just because there weren't enough paralegals and there were too many matters that were coming in and different calls that were outside of scope. So instead of referring it out, we just answered the call.
Okay, so maybe you could tell me a bit about the different practice areas and kind of how the different types of matters that you handle and sort of how everything's kind of distributed in the firm, and anything more kind of along those lines of the different areas that you're working in.
Yeah, absolutely. So I am exclusively a landlord representative. So I represent landlords before the LTB, and basically the firm deals with any other issues that a landlord might have. So small claims, criminal, corporate, real estate, wills, anything that any person would have, we deal with. It's a full service firm, so each partner here is responsible for their own area of law. And that's how we really grew the business. Now, of course, we get matters, not exclusive to the landlord, but we do kind of stick to that corporate business business geared service.
All right, so let's maybe walk through some landlord issues that come. Let's start obviously from the landlord tenant board, right? What are the most common phone calls? You pick up your phone, they're like, Brenell, I need your help. What's the first words out of the client or prospective client's mouth, and what maybe you can kind of walk us through some of those matters?
It is absolutely that the tenants have stopped paying rent. That's pretty much the call that I get because that's the reputation that I have, is that's what I deal with. So I'd say about 80% of our calls from landlords are that tenants are not paying rent, or that they want to move into the property, or that the tenant has caused some serious damage, serious problem.
All right, so let's look at those three issues there. So first of all, how is the landlord tenant board out there in Windsor? Over here, I always hear, I know there's all sorts of articles and reports there a couple of weeks ago, or maybe even last week, about these backlogs and just how, in terms of administration of justice, landlords are feeling, that they're waiting forever. And like if someone's not paying you rent, and every month that you're waiting for the board to have an eviction order and then the sheriff involved and so forth, that especially with mortgage rates going up, if you have like a variable and every month that you're not collecting rent is a serious dent in your pocket. What is it like in Windsor? Is it the same sort of stuff there, or are you a little bit insulated from some of these delays? What's the experience like?
It's the exact same. The delays are incredible. Like for a while there, we had wait times of 9 months. There were a couple files that went over a year. I just got a notice of hearing for a file that's a year and a half. The wait times are incredible. The system is backlogged. I have a number of theories why, but it's just extremely backlogged. It's delayed. Landlords are struggling. Tenants are struggling as well, I'm certain, but those are not the calls that I get. But it's a struggle. It's a big struggle, and I find that the hearing process is it's changing with time. Given the lack of time for a hearing to be held, just because of the overwhelming number of hearings that are scheduled, you really have to get your point across very quickly, or you're going to be put over to another 4 or 5 months.
All right, so let's go. Let's look at that typical call there. Landlord calls you and this says, "Look, they didn't pay rent. Today's the 18th, and I've waited a couple of weeks. I don't have my May rent. Maybe they also don't have the April rent at this point now. They sort of gave them another chance. May didn't come. It's been another 2 weeks. They've been trying to communicate. The tenants not really responding, or they're giving some sort of excuse. So it's wait till the 30th of the month or the 1st of June. I'll be caught up." What's your advice there for landlords at this stage? That they're 2 months behind. They're feeling the pinch. What should they start doing?
They should get legal representation right off the bat, at least to talk with somebody, because what they don't want to do is try to do the process on their own. They wait the 9 months, they get to the hearing, and they find out that they did the paperwork wrong. So now they're waiting another 9 months. I've seen so many files where landlords have had to wait that 9 month period 2 times, thinking that they could do it. It's becoming more complicated, let's say. So I would say that they need to call somebody, get some advice, at least get the N4 served for the unpaid rent. And if the tenant pays in the 2 weeks, great, no harm, no foul. And if they don't pay, you got to file with the board right away.
So what happens once you file the form with the board? Again, you're mentioning 9 months, maybe the timeline, but what can be happening while you're waiting for the board? Anything that or do you just file it and you just wait till your date and try to deal with it at that point?
Oh, absolutely not. Absolutely not. You don't want to just sit on your hands for 9 months. The landlord's struggling, they're missing the mortgage. It's not pleasant. So we would instantly, day one, we go to the property or we call, we try to negotiate something. We try to see if we can get a payment plan. Can't get a payment plan, we try to see, okay, are you thinking about moving? And we just really try to talk with the tenant and see how we can help the landlord to get their mortgage paid.
Now, there's an expression, I guess, cash for keys. What sort of ways, I guess, can the landlord look at if they want this tenant out, and the tenant's trying to beleaguer the process there of staying as long as they can, or they're again feeling that pinch because maybe they're looking at putting it up for sale, maybe they're looking at moving back in for themselves, but they're not sure what they want to do option wise. They haven't filed any notices or anything. So what ways can they incentivize their tenants to just pack up and leave, especially at this point if they're a couple months late on the rent as it is?
So with this situation, we never say cash for keys because the board tends to hate cash for keys. So we don't say that. That's a bad word. We say that it might be conducive that if you want the tenants to vacate, you might have to help them with some moving expenses. So we can do it in a couple different ways. We'll do either, okay, maybe we need to waive some or all of the back rent And that way they can have an opportunity to have a clean start, get the tenant back on their feet. They have a clean start. They can save for first and last and be on their way. We sometimes do it where we find a moving company that's affordable. We pay them directly. Sometimes the landlord might have to help out and pay first and last for a new property. And really, depending on how desperate the landlord is, I've seen the landlord have to cover a whole year's rent for a tenant to get them out and off of their property. But again, that's extreme, and that's when landlords get to desperate situations where they're going to lose a sale, or they're going to lose their home, and that's basically like last resort.
So what are some common mistakes? So you mentioned like the 9 months wait, and then you show up and you've messed up, and now you got to wait another 9 months and file things properly. But what are some common mistakes that landlords make that, if they had legal representation, would have been avoided? What are like the don'ts there on the landlord side, if anyone's listening, to avoid making, to get yourself in worse trouble?
I see landlords very frequently make errors on the notices. Something as small as putting the postal code wrong can void the notice, a typo in the name, not naming all of the tenants over 18 in the unit, improper service, like taping notices to the door is not proper service, not giving the full 14 days on the N4. There can be so many errors, and just when you're going through the forms, you have to read all of the instructions because the instructions are missed so often.
Now, I mean, another one there that you brought up is if, let's say, there is some kind of reason for the landlord to want to take possession of the property again, right? Either they need to do some kind of repairs that require vacant possession, or maybe they're moving back in, or their children are moving in. Maybe they finished their semester at U of T or something in Toronto, and they're coming back home to live. Where does this kind of get into problems for the landlords, when their quote unquote child is coming to live at the property, and then it just turns out that it's just a way to pull wool over the tenant's eyes, and then 6 months later it's up on Kijiji or something, at a rental price that's $500 more to sort of take advantage of. I don't know how the market is in Windsor, but now everything is just going up and up and up. Like $3,000, I think, is going to be the new 1-bedroom rent average in Toronto. But again, they don't want to miss out on all these ways to cover their mortgage. But how does that get them in trouble?
So, I mean, there can be fines, right? There can be fines up to $50,000. There were changes to the act recently that basically says, in the past, tenants usually, if they were illegally evicted based on a bad faith N12 or N13 to move in or to complete renovation, they got moving expenses, the difference in rent for 12 months, and maybe some other some incidental costs. But there's changes to the act recently, so now it's a full 12 months of rent that they could be entitled to, not just the difference. In addition to moving expenses, incidentals, and so on. I personally haven't seen that because what we explain to clients is it's about their intent. If they intend to move in, sometimes that intent changes by the time, you spend 9 months waiting and your intent was to live there for for 1 year while the kid was in school or something, and now they only have a couple months left. If their intent changes, that can happen. There has to be evidence of it. It has to be genuine, but we haven't seen it where it's bad faith and then it's going up. Like there are other ways to end a tenancy that don't involve taking that very serious risk.
And what about like repairs and things like that? Is there a process there? Like, I mean, in terms of, hey, look, I need to do this kind of repair. There's, I don't know, asbestos or whatever, and we can't have anyone here. Are there any procedures that have to be followed so the landlord doesn't get in trouble? Again, of trying to sort of do a renoviction, I think is the term, right? Of getting rid of someone when they don't really have plans, or they don't really need to have vacant possession of the property to do all that?
So, I mean, it's very difficult to have those applications be successful in the first place, but you have to do the N13. You have to give them the proper notice, pay the compensation. But the thing is, there's right of first refusal. So people talk about rent eviction, the tenants have to leave. If there's going to be repairs, when those repairs are done, if the tenant lets the landlord know prior to leaving, they get to come back and pay the same rent. So when a landlord, and the purpose of that amendment to the act was obviously to avoid that. So when you tell the landlord that if their intent was a rent eviction, let's say, they usually change their mind very quickly. But there's other ways to end a tenancy. Like if you're demolishing the unit, if you're going to convert it to commercial and maybe change zoning, maybe it was a duplex, you're going to go back to a single. That there are other ways that can permanently end a tenancy that can be done properly, that don't result in that type of risk.
Now, what about if a landlord wants to sell and we don't know what the intent of the purchasers are? Does that force the tenant out, or what happens, let's say, in the sale process? Like, does it have to wait till the sale has gone through? What if there's a purchase and sale agreement signed? How does that process play out again with the landlord to ensure, as you were mentioning, these dire situations where they're desperate to get the tenant out because their sale might not go through because they're not providing vacant possession or something like that?
Shockingly enough, I do a lot of speaking to real estate agents, brokerages. I give a lot of mentorship, because when a landlord sells a property and a tenant is in that property, the tenant does not automatically move out. You don't just give the N12 and then the tenant leaves. So if they sell the property to a new owner and closing date comes and goes, that new owner will automatically become the landlord. So what happens is, if the purchaser wants to move in, then they have to give a declaration or affidavit saying that they're moving in. It has to be in the agreement of purchase and sale. It has to go be for the board. What typically happens is, the landlord will sign the agreement of purchase and sale promising vacant, giving 60 days to close. And on closing date, the tenants are like, you can evict me at the board. And you have to wait 9 months. And unfortunately, the landlord will be in breach of the agreement. So they'll end up, in small claims over the deposit, or sometimes in civil if it's a bit of a higher amount than 35,000. So it's a serious thing. And in order for that unit to be vacant, the proper steps have to be followed.
And I think the third thing you had mentioned at the start there are like these situations where there's just the troubled tenant that's playing music at all hours, damaging the property. Maybe they have like a illegal drug operation or something going on. So how are you able to evict these kinds of tenants? And again, how long is that process taking? And are there any steps the tenant can take to remedy or resolve their behavior to save them from being evicted?
So basically, with those situations, typically you would do the N5, and that's a document that just outlines in great detail what the tenant's doing that's either interfering with the landlord, interfering with the landlord's legal rights, interests, interfering with other tenants, and so on, damage, all those types of things. That automatically gives the tenant 7 days to correct their behavior. Now, if they don't correct it in 7 days, then the landlord would typically file with the board and go to the hearing. What I've found, though, is if the tenant stops that behavior before the hearing, the board usually gives the tenant another chance to continue their tenancy. So it's not an absolute eviction. The only time when it might be absolute, and this is a great might, is when there's substantial damage, like we're talking, okay, it's $20,000, it's $30,000, and it's just so unlikely that the tenant will ever be able to pay for that damage. That's usually a stronger case than just the tenant is bothering people type of thing.
Now, Brenell, do you have any other advice or thoughts here for any students or anyone looking to get into this area of practice? Now, you're saying like there's so much work there that you need more people to help out. So, what are some tips there for anyone looking to get into landlord tenant? Let's say specifically on the landlord side of what are some strategies there, and what else can they be expecting to do? What's kind of like the day to day in the landlord tenant practice in Windsor there, or perhaps anywhere else, some advice that they can benefit from?
Absolutely. So the first thing is you have to have thick skin. Landlord tenant is, from what I'm told by our lawyers, that it is the most difficult area of law because adjudicators have discretion, and discretion means that a lot of the things that you're arguing will not be black and white. One day it will be decided in one way, and the next day it could be decided in a different way, and that's perfectly fine. So you have to have thick skin to be able to deal with that. Typically, this is the most heated area of law. So by that, I mean you have a landlord, it's their home. You have a tenant, it's their home, right? So there are arguments, there are fights. I've been threatened for my life. Tenants have came to the office, and it's been a little bit frightening if you're not prepared. It's the area of law where you really have to have that thick skin. I'd say the other thing is client management, and upfront, you have to manage your client's expectations. The wait time for a hearing will be long. There's no guarantees that we can shorten it. We do our best, and managing those expectations will save the landlord disappointment and will also help them to prepare, because that way they can try to access funding and loans and try to prepare for the very real possibility of 1 year without their income. So, managing those expectations is not only good for you because you don't have to deal with, the stress of an angry client, but also good for the client so they can be prepared. And I'd say the third thing is you have to bring your work ethic to the table. This profession, there's been a lot of talk lately about work-life balance and taking it easy. And although in theory that's great, when you're practicing in landlord tenant, like I said, it is an area of law that tends to get very heated. There's a lot of emotions, and frequently, because of just the overwhelming number of cases, it's not a 9 to 5 really. It's more, when I hire, which is why it's probably difficult to hire, I'm very upfront that it's usually 8:30 to 6. And that's because at the board, your hearing is scheduled for 9, but you can be waiting for the hearing to start until 4. So that means you might not do your client meetings until 5. You have to update the client, you have to invoice, you have to run the business, and so on. It's not realistic to think that if your hearing is at 9 and it could go till 4 o'clock, you're going to be in at 9 and out at 5. So you have to bring that work ethic, and you have to really have a passion for the law. And when you do have that passion, it doesn't feel like you're taking away from work-life balance. It just feels like you are doing what you're passionate about. And it certainly doesn't feel like, at least for me, that I'm overworking myself when I work 10, sometimes 12-hour days. I'm really enjoying what I'm doing.
Now you talked a bit about the hearing process, and certainly once you've filed and it's gone and you're waiting. Now before, I mean, when it was in person, there was certainly the ability to have it mediated on the spot right before you'd have the hearing. So how does that work now in sort of the Zoom Teams era? Are they still happening kind of the same day as the hearing in terms of mediation if both parties, and maybe you can kind of explain how if both parties agree, that how the mediation process works?
Yeah, so at the beginning of the day, the moderator at the board will kind of vet people to see who is open to possibly discussing any type of mediation negotiation. And if you are, some point throughout the day, between 9 and 4 o'clock, you will then go into a private video room with yourself, the other person, and a mediator, a dispute resolution officer with the board. Some days that mediator is not available, and it's just you and the tenant if you're represented trying to work something out. But basically, if you come to a resolution there, and if a dispute resolution officer is available, they will prepare that order. You don't have to go to the hearing. You no longer even have to go before the adjudicator. They will actually prepare the order and send it out much faster than waiting on a decision for a hearing.
And what happens if one of those orders then is subsequently breached by the tenant?
So if the agreement is something like a payment agreement, the landlord has to file an application within 30 days saying, okay, there's been a breach. And then that has to go back before the board. And then a written order will proceed at some point after, between, let's say, 30 and 90 days. And that would basically, depending on the order and the tenancy.
Now, and let's say if there is no mediation or it doesn't resolve the matter, can you kind of outline what the hearing process itself is? Like you already mentioned, you may be waiting hours till they get to your matter. So let's say 2 o'clock finally rolls around. You've been sitting refreshing, the screen, kind of get some other stuff done. So it finally rolls around. They say, Brenell, are you ready to proceed? The tenant is, self-represented. So that also, maybe you can talk a bit about how hearing functions when you're representing your client on the landlord side and you have a tenant that's self-represented, and maybe kind of walk us through the steps of hearing, how it starts, and how it gets to the order from the adjudicator.
So tenants are frequently self-represented. For some reason, a lot of representatives don't take on the tenants' matters, is what I hear. I don't really know. That's just the decision that I made when I started. But I try to keep my hearings as consistent as possible, whether it's represented or not. So I try to just open with, what am I asking for? What is the landlord's case? I question the witnesses, and then the other side will get an opportunity to talk. And then we just summarize what each side said, and it closes. Now, what can happen if a tenant is self-represented, they will interrupt, usually quite often, because they feel like, typically I find it almost feels like it's more of a conversation. Now, if you get a more seasoned adjudicator, they can hold down, how the room operates. They will stop the tenant. They will try to keep some type of formality. But sometimes that just isn't possible. Sometimes, the tenants do kind of interrupt, which delays the entire proceeding and then typically leads to adjournment. I don't have a problem when that happens objecting and asking for costs, because the rules allow you to ask for costs if somebody is delaying the hearing unnecessarily. So I try my best to object, to make my points very quickly, and that way we can move on and there's time for another matter. After the hearing, sometimes the adjudicator will give their decision verbally, but you still have to wait for that piece of paper to come to say what the official decision was. And sometimes you'll have no idea. They'll just say, we're gonna wait, and it gets sent out. Now, the wait time for an order, they say online that it's 30 days. In my experience in the last 5 years, it's not 30 days anymore. It's more like anywhere from 60 days to 6 months. I've had a couple hearings where the order was never written and it had to go back to another hearing. So just because you get to the hearing doesn't mean the process is over.
And so what happens, I guess I have some students that are learning about debtor creditor. So what happens, let's say you get your order, you get the eviction, but the landlord still owed, I don't know, $15,000, let's say, in unpaid rent. one of the things they're to learn about is the difference between the people who can't pay and then the people the sort of they will not pay, but you still have your clients that are like Brenell, like, okay, I got them out, great, but I still want that $15,000. I want to buy a new car, or I want to go on vacation, or I just need to pay the bank. What can I do, even though they're gone, but I want that money?
So the first thing that I have to do is talk to the client and see if that tenant is collectible. So what I mean by that is, are there any assets that the tenant owns that are worth anything? Is the tenant working? Does the tenant have some type of genuine income? And typically we find if a tenant's not paying rent, they usually don't have income, meaning that they're on Ontario Works or they could be on some type of government program. That money is not collectible, meaning you can't necessarily collect that money from the tenant. So if I find out they are collectible, then the process is, if it's under 35,000, then you go to the small claims court, you can garnish the wages, you can garnish bank accounts, you can put a writ on a vehicle, and so on. But that's a big if. Typically, landlords don't know where the tenants went because you have to find them, right? They have to be served, meaning that you have to actually bring the tenants the documents and hand them to the tenant. So if the landlord doesn't know where they went, and doesn't know what assets they have, I typically have to get a private investigator to connect with the landlord to find the tenants, and that costs money. And typically, after a landlord hasn't received rent for a year and they're owed $30,000, they might not have that money to hire a private investigator. So the other option is just to put the order into a collection agency and hope for the best, right? And my office doesn't feel comfortable taking legal fees when we just don't know, or don't usually, I won't say we don't know, we strongly believe that the tenant is not collectible, or there's nothing to indicate that they are. So we will typically tell the landlord that we won't take their money to try to collect if there's no reasonable prospect of collecting that money.
And I guess, how does that conversation go, right? Because I mean, are you finding that the landlords are like happy, at least they can get income back from their property, or they can sell the property or move into the property or otherwise make use of it? Or do they sort of feel like there's got to be a way to somehow get this money? Maybe the tenant's going to win the lottery one day, and if there's a way to kind of keep chasing after that, or how often do you find that garnishing wages or something like that tends to be something that's that they're able to collect something out of it? Or what are your thoughts kind of in sort of collections once once you're at that stage?
So I talked earlier about managing client expectations. So right at the outset, I would be explaining to that client, look, if the tenant isn't working and is on some type of assistance, the chance of collecting is very difficult, right? So they already know that, they've already prepared. We've partnered with real estate agents, we've partnered with private lenders, we partnered with mortgage agents. We try to put our clients in contact with the right people to make sure that they can get the funding and have that advice that they need. So that way, when they are at that point, they might have, some type of plan B that doesn't revolve around waiting for the tenant to pay. But realistically, like the conversation at the end for me is very straight. It's very straightforward. I don't like to sugarcoat it. I just tell the clients, look, at this point, I'm going to tell you to contact a private investigator. Here's a couple options, and let's hope that we can find the tenant. Let's hope that they're working. Now, usually a month or two down the road, they email me back and they say either they found the tenant, they're not working, they're on long-term disability, or they're on something that's not reasonably prospectively going to change unless they win the lottery. Or they say that we couldn't even find them, they're gone, or they're far out of province. So in those circumstances, the conversation just goes, look, there's no reasonable prospect at this time to collect. I would recommend filing the order with a collection agency, and sometime in the future, if for whatever reason they're able to collect money, that's that's an option. But in terms of our firm taking on the file, I never feel comfortable taking the landlord's money with the very realistic possibility that they're never going to get that money back.
Now, in those situations where maybe they located them, or they are working, and it was just more of a, they had fallen on some hard times, whatever, they missed a few payments, and then there was this whole issue at the board, then they lost. How is the process to actually enforce those landlord tenant orders? Do you have to kind of file like a statement of claim and kind of go all through the small claims process, or is there kind of a shortcut to being able to collect and go to the sort of garnishment and enforcement stages?
Absolutely. So you take the order and you file it with the small claims court in the jurisdiction of that order, right? And then, or alternatively, in the jurisdiction where that tenant is located, that order would then become a judgment, right? And then that judgment becomes enforceable. It's an automatic process that's given a small claims court file number, and then that file number can be used to file any small claims court forms.
And so what are the different, like, so we talked about garnishment there. So what are the different ways you can look to enforce, let's say, up to 35,000 in unpaid rent, or maybe damage to the property or whatever it was from the landlord tenant board? What are the different options, again, depending on the tenant and what they may have? And as we've already talked about, it's possible there's nothing you can get, but other than garnishing their wages, what else can you potentially do? Obviously, they don't own a home, otherwise they wouldn't. I mean, I guess they could theoretically be renting and have a separate home that they own, but what are some of the different other options besides garnishing wages that you can do to collect the outstanding amount?
Yeah, if you know where they bank, you can garnish the bank, right? Any accounts that they have, you can put a writ against the vehicle or against property, meaning that when that vehicle or property is sold, you would have first rights to those funds. There's a couple different things. You can bring them into a judgment debtor examination where they are compelled to give answers and give statements and provide documents related to their finances. So you can even get a little bit creative and ask for things like, do you own a TV? Do you own a cell phone? What is the value of any good that you have? And you can basically request for a decision saying that they have to sell those items as long as they're not, children's items or items necessary for work. There's, a few exceptions, but for the most part, anything of value other than those exceptions can be sold.
Now, again, sometimes you may be thinking about this, this may be the last stage, months and months down. But I mean, sometimes you have to think about this from the outset, right? Because otherwise, why would you even start pursuing some of that stuff? Because there's no reasonable prospect of collection, as you pointed out there. So what are some of the things when you're looking at, a client comes and says, well, I don't know if I'm going to get any money from here. I'm just deciding whether to go forward or not. Is there like you mentioned private investigators, but I mean, is there anything else you can look at to see if this is one of those, delinquent tenants, or, the revolving door tenants that they do this to one landlord and then, no one does a background check and they do it to the next landlord, and it's just sort of, rinse and repeat every so often. I mean, what are some flags or red flags that landlords can be looking after or looking out for? And as well, you can mention to them before we even start on this that, hey, I don't think we're going to be getting anything. So I want to let you know, again, as you mentioned, managing the client's expectations, that this doesn't seem like a good road to go down.
So the main goal is eviction quickly, right? So through negotiation, let's get to the hearing as quick as possible when there's no reasonable prospect of actually seeing any money. The goal is mitigate the landlord's damages. Now, what I recommend is to avoid this whole thing is landlords have to do their very best. So vet the tenants. If they don't know how, get a property management company, a leasing agent to check the credit score. and just request all the information. Actually call references, get letters of employment, get as much information as you legally can to see if this person is a good fit. And then the other thing is you can look on what they call CanLE. So CanLE is a legal research tool. Not all cases are on it, but you can search the person's name, see what comes up, search the last known address. So like if they're putting on their application, hey, this is where I lived before, call that landlord and then search the address on CanLE and see where they evicted. Because sometimes if they're evicted, the landlord's just happy to get them out. They'll give a good reference, right? Unfortunately, desperate times. So, the more work you do in the beginning, like sometimes I find landlords are in a very big rush because, they waited a year and now they need to get somebody else in, but they will end up very quickly in the same situation. So take that extra month or two, find a good tenant. It will save you many months of hassle. And then the other thing is landlords always tell me, I just knew from the beginning that it wasn't a good tenant, but I felt bad. Trust your gut. Being a landlord, even if it's a family home or whatever have you, it's a business. So you do have to make those business decisions and say, look, I'm not going to invest in this person, unfortunately. You want to be nice, you want to be caring, but at the same token, the risk to the landlord is quite great. So most of my clients say that, I just knew it. I thought that they were good people. They just fell on hard times, which happens. But at the end of the day, if you do your homework, you'll probably see that this is a reoccurring situation. I can tell you at my office, I have evicted the same tenants in 5 years, probably at least 3, 4 times. Like I see this, it's the same exact people that I'm evicting over and over. And sometimes what they do is sign multiple leases, Airbnb out the landlord units, and then, don't pay rent and just let the board run its course. So sometimes I get the same tenant simultaneously. But if you Google the name at least, or go on CanLE or look anywhere, I make sure that my orders, hopefully at some point I submit them, but most of them aren't on there. But hopefully at some point they will end up there because it's very common. And I don't just practice in Windsor. I'm across Southern Ontario, and even in the GTA, it's the same people. It's not really new people in typical circumstances.
Now, Brenell, I want to spend the last 10 minutes here. I mean, as much as we've had a nice, really thorough overview of both the LTB and then the enforcement part in small claims. I know you're also teaching as well. So maybe tell me a little bit about how that experience has been and what are the, how it's been with your students and in college there and the whole, what led you into that teaching opportunities.
Absolutely. So I was asked to teach very early on, I think as early on as LSO allows. I got a call one day just saying, hey, I got a class and we want you to teach it. So I find that networking is a big thing. And just having a good reputation, being professional, being ethical goes a long way. I taught at St. Clair initially, and I started out with a practice management class. I went on to justice at work. And I just found that with that college that I was teaching maybe 50, 60 students, sometimes more. And it was very hard for me to offer the type of mentorship that I like. So after I've had 2 children, so after some life changes, I decided that I couldn't maintain at the level that I felt comfortable with and give the students what I wanted them to have to be very successful. So I've transitioned to a smaller college, Anderson. My class sizes are about 12 or 15, and it's very hands-on. And when they contacted me to teach there, I was really surprised because it was actually one of my instructors from when I took the program at St. Clair, being now six years back. that instructor remembered me and asked me if I wanted to teach at Anderson. So I jumped on board. I'm teaching. Last semester, I taught criminal, and this time I'm teaching criminal evidence and civil litigation and landlord tenant, of course. So it's just a really enriching process. It helps to break up my day, break up my week, and it helps me to give me some hope because, like I said, I'm trying to hire and I'm wondering what's going on with the students. They're not practicing, they're not staying in the profession long enough. So I figured teaching at the small college, it's easier on me, and I can give the students a lot of hands-on.
And the other piece there, I mean, I certainly see a lot of your posts, being involved on LinkedIn and social media. And you were talking about your 5-year anniversary, and I think highlighting diversity at your firm, right? We were talking about, I mean, diversity, the fact that there's paralegals and lawyers there. But I mean, one of the things certainly in our profession, we're looking at different ways. You know, a lot you might see in your classroom, right? I look at mine, and there's people from all over the world, different ages. And again, I'd like to certainly see them continuing on in the profession and succeeding. So maybe you could tell us a little bit about how you kind of started posting and what the response has been. And again, anyone that's thinking about sharing, and then there's always this like feeling of self-doubt or imposter syndrome, like, oh, who's going to want to listen to what I'm sharing? Because I mean, I see a lot more students are posting as well, and I think it's great. But anything that you can kind of encourage sort of that networking and seeking mentorship and putting information out there on platforms like LinkedIn.
Well, I'll tell you this. When I started five years back, and even when I was first in school, I was in a class of about 50 students. I was the only Black person. So when I first opened, I was so hesitant to put my face out there, not because I had doubt. I'm a very confident person, but I said, well, I want to get the brand that the clients will appreciate. And it was very quickly that I said, you know what, forget it. I'm going to put my face out there. I'm going to just keep being very professional, ethical, and really work very diligently. And it paid off. And now I'm noticing my classrooms are very diverse. At my office, I made it a point to just, take the resumes as they come. I do not look at names anymore when I read the resume. I just look at the context first, and then I bring them in to just avoid any unconscious bias. And I think that will help the profession grow. And I've noticed some substantial growth. I'm really happy to see all of the different diversity that's coming from all different ethnicities, backgrounds, ages. It's just really awesome. And I wanted to make that post to just encourage people and to challenge some people do the same. My clients appreciate it, and it worked out really well.
Now, Brenell, thanks so much for taking the time here and joining us today. Last question, you were sharing some advice in the context of advising landlords, but I mean, you have students, again, before you had like 50 students, now have a smaller class, and certainly people may be looking to you for mentorship. And those, as we were just talking about, looking to get into the field and are kind of lost, once they get through the licensing exam. I know you have to post there congratulating people about that, but kind of looking at those next steps. So any words of wisdom, if you think back now in the 5 years you've been running your practice, if you can go back 5 years ago and say, here's some advice to kind of get you from the stage now of being licensed or from in the classroom to succeeding. So, when they're 5 years out, they're going to be thriving as you are. And again, thanks once again for taking the time to join me.
Thank you. You know what, I'll just close with saying that 5 years back, I just plunged in. I got my P1 number. I had no mentor, and I just started the business the day I got the P1. I got insurance and I opened. It wasn't easy, especially without a mentor, but I did it. I'm very successful, and I just recommend that everybody that is really able, work hard and just jump in. Don't hesitate. You can research, you can do it, you can learn. It just takes a dedication.
Perfect. So once again, thanks so much for taking the time to join us, and thanks for everyone for tuning in. All the best, and take care, Brenell.
Thank you.